April a storm. Past a lot of fallen down trees coming here. Somebody asked, what is parole evidence? And that's a very good question. First of all, it's parole spelt without an E on the end. I'll let people in the comments figure out the etymology on that because I don't actually know. But what that rule says is, when you are trying to establish what the meaning of an agreement was, you know, like a contract, the starting point is you just look at the document itself and not anything outside that document. It's what we call the four corners rule, it's sometimes referred to, in that your starting point is, right, what have you written down? Okay? Because we have this idea of what we call the intention of the parties. And courts are often asked to sort of establish this. What did people mean? And the problem is, intention of the parties can be, well, something that neither side actually thought was what the agreement was. But the court says, well, no, this is actually what you intended to do, even if you didn't realise it at the time. So that's the starting position. Sometimes people make it very explicit. They will put a clause in a contract, what we call a whole agreement clause, saying this is the whole agreement and nothing outside the contract, including any misrepresentations, can be relied on. Because what you're trying to avoid is a situation where the court's looking at a document and says, well, clearly it says here that you'll pay X or you'll do it by such and such date. And people are saying, yes, but it was agreed between ourselves and we're sorting this out, that there's something different. Because the rule with a contract is, you have to be able to, it has to be what we call certain. Contracts can be void for uncertainty. And that's where there's something in there that is ambiguous. Now, you can refer to external sources. I mean, a very common one is, in the event of any breach, we will put an arbitration clause in there. So somebody else can come in and we will agree to be bound by their decision. Or we will charge the normal bank rate plus 2%. So obviously you need to go off and look at the normal bank interest rate at the time. Things like that are permissible. I mean, but the idea is somebody reading the document should be able to say, I can see exactly what they intended. Now, one thing, even though you can say, right, you can't rely on a misrepresentation, and I'll discuss in a minute what a misrepresentation is, that's only a negligent misrepresentation. Now, the law now treats negligent misrepresentation the same as fraudulent misrepresentation, because in the olden days, you could only really claim damages for fraudulent misrepresentation. But now they said, actually, it's the same rule for where it's negligent. So it's not somebody who was deliberately lying, but they just got something wrong, or there was a misunderstanding. And because of that, courts no longer have to determine whether somebody was actually deliberately dishonest. It's just, no, you got it wrong. However, if it is a genuine fraud, where somebody has misled you intentionally, that can vitiate a contract. Fraud vitiates everything, as we say. So that is an excuse for saying the contract can be rescinded. But generally speaking, if there's a clause like that, then the mere fact they say, well, hang on, he told me this, but that was wrong. It's like, well, tough, do your own due diligence. All that's excluded. And what is a misrepresentation? Well, it's a misstatement of the circumstances that induces you to do something you wouldn't otherwise have done. So if you would have signed the contract regardless, then even if somebody did misrepresent something, you can't get out of it, because it's, it's like, well, actually this car's got, 50,000 miles on the clock, but it's got 100,000 miles on the clock. But you'd have bought even with 100,000 miles on the clock, then the misrepresentation is not active. So it doesn't count. A misrepresentation usually has to be a positive statement. Merely not mentioning something usually isn't a misrepresentation. But a half-truth can be. And also, if somebody asks a question and it's clear that they're examining a particular area. I mean, you see this all the time with house contracts where, you get those standard forms, are you having any disputes with your neighbour? Do you know exactly where the boundaries are? Who takes care of that hedge? Well, you've got to answer those questions truthfully. But if somebody came along and said, is there anything wrong with this house? Or is there anything wrong with this car? Then obviously that can be a little bit subjective, but generally speaking, they're putting the onus back on the vendor to actually come clean. So yeah, there you go. So it's not a particularly complex thing. It's just saying that the starting point with a contract is you just look at the contract. And like I say, you can firm that up by putting in these whole agreement clauses, but they're not necessarily the be-all and end-all, but courts are very, very reluctant to interfere in contracts, because they basically say, look, the parties knew what they were doing, they had the opportunity to get sort of, legal advice. Tough, you've signed up to it. So there you go. As always, hope you found that vaguely interesting, and you can see me because it's very, very dark here. If you did, please consider liking, subscribing and sharing. But as I always say, perhaps I shouldn't, because that's probably why nobody subscribes. You don't have to. I just enjoy doing these for you. And this is a lovely spot, actually. There's somebody better than me would just pan around and show you what I'm looking at. But I'll do that next time.